Below, I will fact-check the provided content within the Malaysian legal context and refine it into a persuasive, technically sound judicial review case, arguing that the requirement to display medicine prices publicly does not apply to general practitioner GP clinics. The content asserts that GP clinics should not be required to display medicine prices publicly based on interpretations of several Malaysian laws and a federal court judgment. Let's verify the key claims. Federal court judgment in. The Court of Appeal in this case ruled that registered medical practitioners could dispense ivermectin to patients under the Poisons Act 1952, implying that the Sale of Drugs Act 1952 does not govern their dispensing activities. Poisons Act 1952, Section 19(1)(a). Section 19(1)(a) of the Poisons Act 1952 states, a registered medical practitioner may sell, supply, or administer such poison to his patient for the purposes of the medical treatment of such patient. The interpretation that this limits sales to registered patients only and not the public is accurate. Trade laws and price display requirements. The government seeks to enforce price displays under the Price Control Act 1946, Consumer Protection Act 1999, and Price Control and Anti-Profiteering Act 2011, treating doctors as sellers of medications. Price Control and Anti-Profiteering Act 2011, Section 9. This requires sellers of price-controlled goods to display prices conspicuously for intending purchasers. Core argument. Since only registered patients can legally purchase medications from clinics under the Poisons Act 1952, the requirement for public price displays under trade laws is inapplicable, as clinics do not sell to the general public. Conclusion of fact check. The content's legal references and interpretations are largely accurate. The Poisons Act 1952 and trade law citations are correct, and the distinction between dispensing to patients and selling to the public is valid under Malaysian law. In the High Court of Malaya at location, between name of applicant, a registered medical practitioner operating a private clinic, applicant and Ministry of Domestic Trade and Consumer Affairs or relevant authority, respondent. Grounds for judicial review. Ground 1, ultra vires. The directive exceeds the respondent's statutory powers and is inconsistent with the regulatory framework governing medical practice in Malaysia. Poisons Act 1952, Section 19, Subsection 1, Paragraph 18. This provision authorizes registered medical practitioners to sell, supply, or administer poisons solely to their patients for medical treatment. Misapplication of trade laws, the Price Control and Anti-Profiteering Act 2011 and the Consumer Protection Act 1999 regulate retail sales to the public. GP clinics do not engage in retail trade. Legal precedent. The Federal Court affirmed that the Sale of Drugs Act 1952 does not apply to registered medical practitioners dispensing medications to patients. Doctrine of the specific provisions of the Poisons Act 1952 prevail over the general trade laws. Ground 2. Irrationality. The directive is irrational and unreasonable, failing to account for the unique nature of medical practice. Clinical context. Unlike retail settings, patients in GP clinics do not select medications independently. Doctors prescribe based on clinical judgment. Potential harm displaying prices publicly may encourage self-medication or pressure doctors to prioritize cost over medical necessity. Alternative mechanisms. Price transparency for registered patients can be achieved through direct disclosure during consultations or upon request, as permitted under Section 9, Subsection 2 of the Price Control and Anti-Profiteering Act 2011. Supporting arguments. Nature of clinics. GP clinics are not retailers. Consumer protection. The Consumer Protection Act 1999 aims to prevent misleading price indications to consumers. Industry consensus. The Federation of Private Medical Practitioners Associations. Malaysia FPMPAM has opposed the directive, arguing that medicines are not retail goods and are regulated distinctly under the Poisons Act 1952. Relief sought. The applicant respectfully prays for a declaration that the directive, insofar as it mandates public display of medicine prices by GP clinics, is ultra-vires and unlawful, an order of certiorari quashing the directive as it applies to GP clinics. Costs of this application. Such further or other relief as this honourable court deems just and equitable. The requirement for GP clinics to display medicine prices publicly lacks legal foundation under Malaysian law. This judicial review case provides a robust, legally sound challenge to protect GP clinics from an inappropriate regulatory burden.